Good afternoon. Welcome to those online and those live here at Tully Rinckey to our CLE this afternoon presented by Tully Rinckey and the Albany County Bar Association. We want to thank Tully Rinckey for hosting this, the basics of workplace discrimination. My name is Sandra Goldmere. I'm the Operation and Events Director for ACBA, and I want to thank Alan Shoikhetbrod for presenting this today. He is the managing partner of Tully Rinckey's Albany office, where he assists in the day-to-day operations of the firm, as well as provides input on the firm's long-term strategic vision. He is also the practice chair of the New York State Labor and Employment Practice, as well as a team leader for the Federal Employment Practice. He has extensive experience in federal, state, and private employment law matters, including claims of discrimination, harassment, retaliation, quitom, and whistleblower actions, as well as disciplinary matters. He represents clients before federal and state courts, as well as before the administrative tribunals and agencies to include the Equal Employment Opportunity Commission, EEOC, the Merit Systems Protection Board, the U.S. Department of Labor, Department of Veterans Affairs, Disciplinary Appeals Boards, the New York State Department of Human Rights, the New York State Department of Labor, the New York State City Commission on Human Rights, and the Foreign Service Grievance Board, as well as matters before the U.S. Office of Special Counsel. He also has comprehensive experience in civil litigation before state and federal courts, including Section 1983 actions consisting of constitutional deprivations and actions involving landlord-tenant disputes, breach of contract, and medical malpractice. We want to thank him very much for his time and look forward to the presentation he's going to give today. So thank you so much, and I'm going to hand it back over.
Thank you. Very nice introduction. Thank you so much. So this is essentially an overview of employment laws that apply in New York State. It would not be possible to go over every single statute that applies in New York State in the employment sector. We would be here for days to do so. So this is really just a general overview of what comes up pretty often, at least in my practice, that I see here. I've been doing this at the firm for 11 years and outside the firm as well. So what we're going to go over are different federal laws that apply, like Title VII of the Civil Rights Act, the Americans with Disabilities Act, the Age Discrimination and Employment Act, the FMLA or the Family and Medical Leave Act, USERRA, which is near and dear to the firm, but it's the Uniform Services Employment and Reemployment Rights Act, and then particular New York State laws, like the New York State Human Rights Law, which is specifically Article 15 of the Executive Law, the New York State Labor Law, Section 740, which is the whistleblower statute, New York State Paid Family Leave, and then we'll go over the different complaint processes and options available to employees in New York State. So some of the federal law protections. First, we have Title VII, which is codified in the United States Code at 42 USC Section 2000E. So this applies to employers that have at least 15 or more employees for at least 20 weeks out of the year. For employees, it applies to part-time, full-time, suspended employees, and also employees on leave. A labor organization also falls under Title VII if it has 15 or more employees, but there's no minimum size for Title VII's application to employment agencies. But what Title VII prohibits is discrimination against an individual based on the terms, conditions, compensation, and privileges of employment based on that individual's race, color, religion, sex, or national origin. It also prohibits retaliatory discrimination, which consists of essentially opposing unlawful harassment in the workplace. That could be also filing a charge with the EEOC, testifying or assisting or participating in an investigation, proceeding, or hearing regarding an unlawful employment practice. So there are different types of claims under Title VII. What we frequently see is something called disparate treatment. What that essentially means is that it's intentional discrimination where someone is treated differently based on their protected class compared to similarly situated individuals. So there is an impermissible motivating factor standard that applies to that, and the employer is prohibited from discriminating based on the motivating factor. There's also something called disparate impact, which doesn't really have a discriminatory intent, but instead it's a disproportionate impact on a protected category or a group of individuals that may be based on a neutral policy or a practice that impacts that group. There are some procedural requirements in raising a claim of discrimination under Title VII. Predominantly, it is going to the Equal Employment Opportunity Commission. The recovery is quite limited under Title VII, and it's actually codified at the code in two different places, one at 42 USC 1981A and the other at 42 USC 2000E-5. But the types of relief that are recoverable are compensatory damages for intentional discrimination. So again, going back to disparate treatment specifically, what compensatory damages consists of is pecuniary and non-pecuniary damages. So what does that mean? That means pain and suffering damages. That means back pay, benefits, and the like. Injunctive relief is also something that can be obtained, but the amount of compensatory damages is limited by the size of the employer. So for example, if an employer has between 14 to 101 employees, the maximum amount that you could recover for compensatory relief is $50,000. If the employer has 100 to 201 employees, the limit is then increased to $100,000. If the employer has 200 to 501 employees, that limit then is increased to $200,000. So 500 or more, the statutory cap is $300,000. It also consists of out-of-pocket expenses, so medical expenses, actual costs, again, pain and suffering. Back pay is limited to 2 years, and 2 years that's preceding the filing of a charge with the EEOC. And then again, enjoining the unlawful employment practice that's being complained of, and then also ordering appropriate affirmative action. One additional thing that can be recovered is punitive damages. There is an exception to that. You cannot get punitive damages against the government. You can't get punitive damages against a government agency or a political subdivision, but you can against a private employer if the conduct is with malice or reckless indifference. And we also have the Americans with Disabilities Act. So here, it essentially prohibits differential treatment based on harassment, based on the individual's disability or perceived disability. The statute says basically regarded as having a disability. The protections apply to recruitment, to firing, hiring, training, job assignments, promotions, pay, benefits, layoffs, different types of leave, and other employment-related activities. The ADA is codified at 42 United States Code 12101. It also precludes from limiting, segregating, or classifying disabled individuals, subjecting employees of contractors to behaviors that are prohibited under the ADA, excluding or denying equal job or benefits due to qualified individual disabilities, failing or denying a qualified individual with a reasonable accommodation. And the accommodation requires that individual to be able to do the essential functions of their job. That accommodation needs to be effective for the individual, and it cannot be an undue hardship. You can also not deny employment opportunities because it will require the employer to make reasonable accommodations for that individual. And you can't basically use qualification to screen out individuals with disabilities. There is also an employer requirement here on the size. Just like with Title VII, you need to have a minimum of 15 employees for the ADA to apply. For state or local governments and employees of those entities, it could be any size. It also applies to employment agencies and unions And for the federal government, the Rehabilitation Act applies instead of the ADA. So a claimant must demonstrate, again, the employer is subject to the ADA based on, the size for private or any other entity, as we just discussed. They need to establish a disability under the meaning of the law, and disability under the ADA is construed broadly, and it's in favor of extensive coverage, but it's essentially defined as having a physical or mental condition that substantially limits a major life activity. And what a major life activity can be could be like walking, talking, hearing, and this sort. It could also be someone that has a history of a disability, or again, regarded as having a disability. So if your employer believes you have a disability, but you don't actually have a disability, that's covered under the ADA as well. The individual must be qualified to perform the essential functions of their job. So essentially a qualified individual with a disability, meaning that they have the legitimate skills, experience, or education, or other requirements for that position. If they are already in the position, they need to be able to do the essential functions of that position. Whatever those essential functions may be something that's in a position description or a job announcement, but essentially what you do on a daily basis. The claimant must also establish an adverse employment action that was due to their disability. An adverse employment action can very well be a termination or not being promoted or any deprivation of terms and conditions of their employment can be an adverse employment action. We also have the Age Discrimination Employment Act of 1967. This is codified in the United States Code, once again, at 29 USC 621. And the ADEA protects individuals over the age of 40 from being discriminated against based on their age. Again, to raise a claim, they must essentially comport with the EEOC requirements. There's certain procedural requirements. The ADEA is a little distinct in that regard. You can certainly file with the EEOC, and we'll go over that later on as to how to do so and the time limits for doing so. But the one big difference with the ADEA is that they can file with the EEOC and essentially wait 60 days and then go to federal court after that, which is a little different compared to Title VII or the ADA. There's also a different requirement for the size of an employer. So the employer must have at least 20 employees, while Title VII, the ADA has 15 or more. But just like with the other statutes, the size does not really apply to the federal, state, or local governments, employment agencies, or labor organizations. The other distinction here is that you cannot recover compensatory damages or punitive damages under the ADEA, but you can get liquidated damages. You essentially just need to establish that the conduct was malicious or a reckless act of discrimination, and the liquidated damages that may be awarded is essentially double the back pay. It does cover a lot of different things, just like the other adverse employment actions we discussed with the ADA and Title VII. But essentially, you cannot make a decision against an employee's terms and conditions of their employment because of their age. Certain people do get, certain settlement agreements, and if you're over the age of 40, those settlement agreements do require certain waivers under the ADEA or the Older Workers Protection Act. That's a statutory requirement for you to be able to waive an age claim in a lawsuit or in a settlement. There's also minimum requirements for pensions under the statute, and prohibits mandatory retirement age requirements in a lot of different sectors of employment. And then we have the FMLA. So the FMLA applies to covered employers, and it does require covered employers to provide their employees with certain lengths of unpaid leave for a qualified medical reason or familial reasons that we'll discuss in a moment. But a covered employer is someone who employs 50 or more individuals in 20 or more work weeks in the current or preceding calendar year. In addition to public agencies like the federal, state, or local governments, and the 50 or more requirement applies to those who work in the United States or any territory or possession of the United States. So you might have a U.S. company that has employees in another country, for example. The FMLA may not apply to those employees in other countries because they're not in the United States, or they might not be in the territory or in possession of the United States. What's also interesting that as long as the employee's name is on the payroll records, whether or not they've received compensation for a particular work week, they would still be covered under the FMLA. Also, the employee can be on paid or unpaid leave as long as there's a reasonable expectation they'll return to active employment and still be covered under the FMLA. So it also applies to part-time employees, temporary employees, seasonal, and full-time. But the benefit is 12 work weeks during any 12-month calendar year. And the reasons that you could receive FMLA benefits is the birth of a child or care of a newborn child, placement of a child with the employee to foster or adopt, to care for a spouse, child, or parent of the employee if the spouse, child, or parent has a serious health condition, the employee has their own serious health condition, or for qualified exigencies such as those related to a family member's deployment. Now, generally, FMLA is 12 weeks for the employee. The exception is for a military caregiver, that of a spouse, child, parent, or next of kin. The leave is instead 26 weeks. If an individual does utilize FMLA, they are entitled to be restored in the position that they held prior to the commencement of that FMLA, or to an equivalent position with equivalent pay, benefits, and other terms or conditions of employment. And while they're on FMLA, they're also entitled to continue on with their health insurance, and the employer is required to provide that. So, violations of the FMLA can be filed with the Department of Labor, but it's not required. The employee can certainly go to the Wage and Hour Division of the Department of Labor, but they can instead commence lawsuit in federal court instead. But the employer is prohibited from interfering with, restraining, or denying the exercise of, or the attempt to exercise of, any FMLA right. Employer is also prohibited from discriminating or retaliating against the employee or a prospective employee for having exercised or attempted to exercise any FMLA right. The employer is prohibited from discharging in any way or any other way against a person, whether or not an employee, for opposing or complaining about unlawful FMLA practices. And all persons, whether or not employees, are prohibited from discharging in any way discriminating against any person, whether or not employee, because that person has filed a charge, has instituted or caused to be instituted any proceeding related to the FMLA. And again, they can file with the Department of Labor, Wage and Hour Division. They can go to file a private cause of action in court directly instead. But there is a statute of limitations, and that statute of limitations is 2 years. If you are alleging the conduct or the violation was willful or intentional, the statute is extended to 3 years. The big differences with FMLA recovery is that although you can get equitable relief and damages equal to lost wages and benefits and actual costs incurred, you are not entitled to compensatory damages similar to the Age Discrimination Employment Act, and you're not entitled to punitive damages. However, you can get liquidated damages, again, if you establish a willful violation, and that is essentially double the recovery of any back pay. Then we have USERRA, the Uniform Services Employment and Reemployment Rights Act, again codified in the United States Code at 38 U.S.C. 4301. And USERRA protects civilian job rights and benefits for veterans and members of the active and reserve components of the U.S. Armed Forces, prohibits against discrimination of military service members in employment, in their civilian employment. It also entitles them to re-employment rights for returning service members. There is a motivating factor or substantial factor standard that applies to USERRA. And that employee, when they return, they are entitled to their job back, or something called the escalator principle, which is essentially any rights, benefits of employment that they would have received but for their military service. The employee also can continue their health insurance with the employer at their option, or really any benefits of employment that any other individual would receive, the service member is entitled to as well. USERRA claims can be filed again with the Department of Labor, and the Department of Labor has a separate branch for this called the Veterans Employment and Training Service, so DOL vets. You can file a complaint with them. You can file a complaint with what's called a ESGR, the Employer Support of the Guard and Reserve. And you could try to settle the matter through essentially an administrative action with DOL, but you're not required to do so. If you're a federal employee, federal employees have very unique rights on how to enforce their rights, and they can go to something called the Merit Systems Protection Board, which is a tribunal. Outside of that, if you work for the state, according to a recent Supreme Court decision, you can certainly file in a court within that state. If you work for a private employer, you can commence action in a district court. USERRA, unfortunately, like other statutes we discussed, does not provide for compensatory damages, but it does provide for corrective action. So, for example, if you were terminated because of your military service, you are entitled to the back pay that you've lost, any lost benefits and interests. There are certain changes in the law recently under the Dole Act where liquidated damages have been increased, and attorney's fees are mandatory now under USERRA as well. Now we get into particular New York State statutes that apply. So we have the human rights law, which is codified in Article 15 of the executive law, specifically in Section 296. Human rights law is interesting because it does not only protect against discrimination in employment, but also in housing and education, credit, background checks, and so forth. But here we're specifically talking about employment. And these individuals have basically several different options in how to enforce their rights. We'll talk about later, but they can go to something called the Division of Human Rights in New York State, or they could bring a private claim or a private cause of action in court. But the human rights law is much more expansive in what it protects, or what it prohibits rather. And it prohibits discrimination against an individual based on their age, race, creed, color, national origin, sexual orientation, military status, sex, disability, predisposing genetic characteristics, marital status, familial status, pregnancy-related conditions, citizenship, immigration status, gender identity or expression, or domestic violence victim status. And like the other laws, it also prohibits against retaliation for opposing unlawful discriminatory practices based on these categories above. What's also unique about the human rights law, for example, in terms of age discrimination, while the ADEA applies to those individuals that are over the age of 40, in New York State, you cannot discriminate against an individual if they are 18 years or older. And the human rights law applies to any employer, any size employer, so there's no minimum requirement here either. So what it prohibits includes publishing or advertising prohibited discriminatory consideration advertisements for available employment. It protects employees who speak out about employment practices prohibited by the human rights law, and again, prohibits retaliation for engaging in what's called protected activity. It requires employers to make reasonable accommodations like the ADA for an employee's physical and mental disabilities, unless the accommodation would impose an undue hardship on the business. It determines when employment interference with religious practices rises to the level of unlawful discriminatory practice. Employer is obligated to make a bona fide effort to reasonably accommodate an employee's religious needs, unless that accommodation would also cause an undue hardship like a disability. It does discuss holy days or Sabbaths. The employer may elect to consider time off for holy days as paid leave, but not sick leave, for example. Have the employee make up those hours at another time. It prohibits employers from disclosing or releasing an employee's personnel file in retaliation for opposing discriminatory practices or filing a complaint and so forth. But essentially, the protections are very similar under the federal laws, just a little more expansive. And then we have different complaint options in New York. And so if you are in New York and you're raising a violation under federal law, you can file with the EEOC. The claimant may not file with the commission until the earlier of 60 days after commencement of proceedings under state or local law, or until such state or local law claim is denied. They must file their complaint with the commission within 180 days of the discriminatory practice. In New York State, that's extended to 300 days because there is a New York State agency that also prohibits against similar violations of law. When filing with the EEOC in the private sector is an investigative agency. So they notify the employer of the complaint. They really call it a charge, and they perform an investigation. They essentially ask the employer for their position statement on, essentially what they believe to be the reason for the complaint or the charge. And then the employee receives that response and they can certainly reply to that response. And then it's really up to the investigator what to do from there. They can follow up for more information. They could interview other individuals. They could be hands off. It really depends on who you got. But they will make a determination, and that determination is whether or not there's reasonable cause to believe that the complaint is true and that there is a basis for discrimination here. If they believe there is reasonable cause, then it moves forward to something called like a conciliation process, where the commission will try to eliminate the discriminatory employment practice through a conference or persuasion. There might be a mediation, but at that point, it may become public information after reasonable cause determinations are made. If there is no reasonable cause issued by the commission, the employee will receive a right to sue letter, and they will have the right to then file in federal district court within 90 days of that right to sue. The commission has 120 days to render its determination of whether or not there's reasonable cause, but in practice, that typically does not happen. It could take many, many months, and sometimes, unfortunately, it could take many years. However, the employee has a right after 120 days of filing their charge to request a right to sue. That is pretty important because if you do get a right to sue letter earlier and you file in federal court, there is a defense that you did not administratively exhaust your claims. And unfortunately, that case may be dismissed in federal court. For governmental agencies or employers, there's a little bit of a different process. Certainly, you can file with the commission, but the commission has basically sharing agreements with the Department of Justice. So if you're, for example, filing a charge against the state for a discriminatory practice, and the EEOC determines there's no reasonable cause of discrimination, they will then refer it to the Attorney General's office to decide whether or not there's a reasonable cause of discrimination. And if the Attorney General's office finds that there is, they can pursue the claim and they can commence the action on behalf of the employee. Similarly, outside of the state, if you are going after a private employer for discrimination, if the EEOC finds there is reasonable cause of discrimination, the EEOC has the option to prosecute that case in federal court. But again, that's very rare. and that tends to be based on systemic issues in the employer's business. But the EEOC definitely has the authority to seek injunctive relief if they choose. They could preclude or prohibit discriminatory practices from happening in the future. They can seek actual damages, including lost wages, going back to 2 years, again, similar to what we discussed in Title VII. And attorney's fees are recoverable as well. And then we have the Division of Human Rights. The Division of Human Rights is a state agency. And again, they can hear cases under Article 15 of the Human Rights Law. The employee can file with the division, and previously the statute used to be 1 year if the conduct occurred before February 2024. After February 2024, the statute has been modified and increased to 3 years. The one exception was for sexual harassment discrimination. The statute was modified in 2020 of August to 3 years. But essentially, you would file your complaint by mail if you choose, or on the division's website at dhr.ny.gov. And because the division and the EEOC enforce similar protections against discrimination, they are dual filed. So what that means is if you file with the Division of Human Rights, it gets cross-filed with the EEOC. If you file with the EEOC, it gets cross-filed with the division. Whichever agency you file with first is going to be the agency that essentially takes over that complaint and will be the agency that decides whether there's reasonable cause or probable cause of discrimination. When a complaint is filed with the division will investigate that complaint. They tend to be pretty good about investigations and being prompt with that. They will, similar to the EEOC, they'll require the employer to provide a position statement as to their rationale behind the claim. From there, they may request the employee to provide a rebuttal or reply. And then typically, there'll be a fact-finding conference. Sometimes it's a one-party conference. Other times it's a two-party conference. But it's essentially an investigator asking questions about the complaint from the individuals involved or named in the complaint. From there, the investigator can request more information, move the case into a conciliation or a settlement conference, but ultimately, they will also make a determination of whether there's probable cause of discrimination. The employee or the complainant here may withdraw their complaint at any time before a notice of hearing is issued. They can bypass the process, the division process altogether. They don't have to exhaust their claims under the human rights law with the Division of Human Rights. They can go to the Supreme Court of New York and commence a private cause of action there instead. But if the division does find probable cause, the case is then referred to a public hearing before an administrative law judge. So public, literally anyone can watch this hearing, which is also very unique with the division. However, if the division does not find probable cause, the complainant there, the employee, their review process is filing an Article 78 special proceeding in New York State Court, where you're going to be limited to the record at the division process, or because it's dual file with the EEOC, you can ask the EEOC to review the complaint and decide whether or not there's a reasonable cause of discrimination. And you have a very short time frame of doing so, unfortunately. Then we have OSHA, which is the Occupational Safety and Health Administration, that applies to the private sector for former or current employees, and also, very uniquely, the United States Postal Service is covered as well. There's two different types of complaints that are filed with OSHA, typically safety and health complaints or whistleblower complaints. For safety and health, OSHA can really only look back 6 months from the complaint. For a whistleblower complaint, they can go back a little further, but the deadlines vary significantly. There's a lot of whistleblower protection statutes that apply with OSHA. many of which need to be exhausted with OSHA before you can commence an action anywhere else. But health and safety complaints typically are limited to being filed within 30 days of the issue. And then, OSHA also looks at different industries like food safety, environmental protection, fraud and financial issues, health insurance, transportation services. And when a complaint is filed with OSHA, a whistleblower complaint specifically, if OSHA closes that complaint, the employee has the option to go to the Department of Labor Office of Administrative Law Judges, which is a tribunal process, and you can certainly go through litigation with the Department of Labor tribunal process, or you can file in federal district court. The complaints can be filed online if you choose, but the whistleblower cannot remain anonymous in an OSHA complaint. And then we have the New York State protections under the labor law 740. Now, there are other whistleblower protections in New York State. There's 741 that typically applies in the medical field. There are protections under the civil service law as well. But 740 is something I want to specifically discuss because it was recently amended and has been expanded pretty significantly. It was amended in October 21 and became effective in January 22. And it provides protections to employees past and present, but also independent contractors. The amendment changes basically from an actual violation to now requiring a reasonable belief that their employer's policy, practice, or activity is in violation of a law, rule, or regulation. Reasonable belief is not defined, but it is largely fact-intensive and situation-dependent. It bars employers from taking retaliatory action against an employee. It does not necessarily have to be within the scope of the employee's job duties for it to be a retaliatory action. But you cannot retaliate because that employee discloses or threatens to disclose a violation, provides information on or testifies regarding a violation, or objects to participation in the violation. And retaliatory action includes actions or threats to take actions that would discriminate against an employee or former employee or adversely impact a former employee's current or future employment, and contacting or threatening to contact immigration authorities. So these claims are filed typically in state court where the claimant resides, or where the retaliatory action occurred, or where the respondent has a principal place of business. There are notice requirements before you could commence suit, that the employer was on notice of the violation prior to raising the claim in court. There are certain exceptions to that, and the exception of putting the employer on notice is whether there's imminent and serious danger to public health or safety, or the employee reasonably believes that reporting to the supervisor would cause destruction of evidence or other concealments, would reasonably be expected to lead to endangering welfare of a minor, or could lead to physical harm of the employee or others. And certainly if the supervisor is already aware, they're on notice. The statute of limitations is 2 years of retaliatory action, but the relief does include reinstatement if that employee was terminated for their whistleblower disclosures, or front pay instead of reinstatement. It includes lost wages, benefits, seniority, reasonable cause, attorney's fees. There's also a civil penalty that can't exceed $10,000, and punitive damages are also available for willful conduct. What's unique about 740 is that if the employee loses, the employer could recover their own attorney's fees. And that's up to the discretion of the court, and typically looked at if the case had no basis in law or fact. Then we have the New York Paid Family Leave, which provides eligible employees with job-protected paid time off there's a 67% pay cap that I'll get to in a moment. But it applies to those that wish to bond with a newly born, adopted, or foster child, care for a family member with a serious health condition, or assist loved ones when a spouse, domestic partner, child, or parent is deploying abroad on active military service. 67% is based on the average weekly wage based on the current New York State average weekly wage. So in 2025, the New York State average weekly wage is $1,757.19. So if you make that much on a weekly basis, your maximum weekly benefit is 67% of that, which would be $1,177.32. That's an increase from 2024 of about $26. So another example, if an employee makes $600 a week, their maximum weekly benefit is $402. But if they make $2,000 a week, then they get the maximum pay cap, which is the $1,177.32. What's different about the paid family leave compared to FMLA? One, it's paid, but secondly, it does not apply to your own serious health condition, while FMLA does. But to be eligible, it applies to full-time employees, those employees who work a regular schedule of 20 or more hours per week. They are eligible after 26 consecutive weeks of employment. It applies to part-time employees, employees who work a regular schedule of less than 20 hours per week after working 175 days of that year. It also applies to individuals that use scheduled vacation time, personal time, sick time, or other time that's been approved. That does count for consecutive weeks or days worked, as long as the contributions are paid into the system. So this is fully funded through your payroll, through your deductions. But if you are on short-term disability leave, it does not count for the work days that apply to PFL. Recently, in January of 2025, workers in New York who are pregnant may also receive additional benefits of paid time off for doctor's appointments, procedures, or other types of prenatal care. It's called the Paid Prenatal Leave Act. It's part of the New York State Sick Leave Program, which is separate from paid family leave. So this is an additional benefit where those individuals are entitled to receive an additional 20 hours of paid sick leave for those purposes. PFL claims, so employers are barred from discriminating or retaliating against employees for requesting or taking paid family leave. Paid family leave is actually enforced by the New York State Workers' Compensation Board. So you cannot bring a private cause of action. Discrimination or retaliation includes not returning an employee to their position or a comparable job. It includes terminating employment, reducing their pay or benefits, or really discipline in any form. There is procedural requirements here. The first step is requesting reinstatement to the employer. There's a form, a very specific form that's available on the website, and the employer has 30 days to respond to that form. And then this next step is completing another form, which is a complaint that is then filed with the New York State Workers' Compensation Board. And they will file that form, and they will schedule a hearing, typically within 45 calendar days of submission. And that is your course code. Do we have any questions?
We don't need that for here. Go to the course code.
I don't think so.
No, they will still need it.
Okay, so I'll go back to that so you can take it down.
It should get emailed to you as well, but you will. Sorry.
Anyone in the room? I don't see anything online.
Yeah, do you want to? I didn't see anything either. Do you want to go to the other final slide so I can? Well, first I want to thank Alan Shoikhetbrod for presenting today about this very interesting topic and important for all of us to know. And thank you to all of those online. We should be sending out evaluations and affirmation forms. Please make sure to fill them out. There was one person online that said it was a call-in number, so if your name did not show up, make sure that you email the ACBA and let us know you were on so that we can send you the correct form. And then there is a slide about some upcoming CLEs that are going on through the ACBA. I actually have two really interesting ones going free, actually.
Did I skip it?
No, it should be after. Oh, there we go.
Okay.
Next month,
Intentionally.
all right, next week we have one via Zoom on ERPO. It is only on Zoom. The one on the 12th of May is ethical emerging issues with AI use and misuse, which I think is also going to be fascinating. It's also available live at Von Schoeneck King or via Zoom. And we also have one coming up at the end of the month regarding ethical issues regarding mental health and addressing mental health concerns in legal practice, so especially in the court system. So if you're a member of the Albany County Bar Association, please look on that. If you're not a member of the Bar Association, there's a lot of events going on. In fact, tonight there was a happy hour that we're all missing because we're not there. But consider joining the Bar Association. There's a lot always going on, and it's an opportunity to connect with other lawyers in our area. So thank you so much for participating, and have a great rest of your day.